Okay, everybody, so let's get started. Again, today's topic is estate planning 101, the basics, the foundation of planning. As I say and tell my clients every day, it's really the documents and plan you have to have in place regardless of age, regardless of health. All right, so we're going to get into the little bit of depth with that um, in just a moment. So again, welcome to our Wednesday webinar. We've been doing these ever since the pandemic began, and we've decided to keep doing them because it's a great way to get this useful information out there. It's a great way for you to share with your friends and family important topics and perhaps different ways to raise the issues so that there can be a discussion. We've been doing various topics, as I mentioned before, Medicaid work for long-term care, asset protection topics, power of attorney specifics, changes in the law, healthcare issues, long-term care issues. If you go to our website, tullyelderlaw.com, there's a video tab and you just click on that, and under webinars, you'll have all the ones we've been doing since we began this. All right. Please check that out, share that with your friends and family. Again, it's a nice way to just get the issue out there for discussion. All right. So let's get started. I'm going to share my screen again here. All right. Any questions, please just type it into the chat box or the Q&A, and I'll be sure to get to it at the end. All right. Now, first question, what exactly is estate planning? Well, I've been asked throughout the years, but the best way to look at it is to realize what topics it covers. Obviously, it's planning your estate. Well, what does that mean? Well, an estate can be your assets, but there's so much more to it. So just by way of reference, so we can all start off on the same foot, to me, when we're talking about estate planning, it covers different issues and different topics. First, of course, is going to be inheritances. We get calls probably daily, somebody saying, I need a will. When they think about planning, when they think about potential future issues, they think about inheritances and having a will. So that is certainly one of the major issues when it comes to an estate plan. We add to that, though, the idea of incapacity, because the will covers just when you pass away. What happens if there is a turn in your health condition, a need for assistance in decision-making or paying of bills? That deals with your incapacity, and that's a part of an estate plan. For other families, and quite honestly, it should be more and more families, it's the idea also of including probate avoidance. And I'll talk about it a little bit, but that's the idea of making your estate plan move a little bit more efficiently, a little smoother, less expensively, and with more privacy. Okay, so that's a great aspect of an estate plan if you can get it into the plan as you put it together. For others, estate planning will include tax planning. There can be estate tax concerns, there can be income tax issues or capital gains tax issues. Not every client that comes in is worried about taxes because perhaps they don't have that net worth or that income level. But again, there's always a handful of clients we're working with that do have those taxation concerns. So therefore, again, a part of the actual estate plan as we move forward. A good chunk of estate planning that we do encompasses asset protection, dealing with how do we shelter our assets in case we need care down the road. So the reality is you have different types of trusts. You have what's called a revocable trust, which might work on the probate avoidance, and then the idea of an irrevocable trust that deals with asset protection. So, and generally that's for clients 65 and above, okay? The final point of an estate plan is addressing your long-term care issues. Kind of ties into incapacity, definitely ties into inheritance, because if you spend all your money on your long-term care, then you're not going to have anything left for your kids to inherit or your loved ones to inherit. So it's all tied into the idea of estate planning, is addressing long-term care issues and, again, asset protection concerns, okay? For purposes of today, though, we're going to be focusing on really the first two, and that's going to be inheritance and incapacity. So the idea is this. Again, as I shared, when people call, I need a will, I need a will, that is only roughly 1/4 of the story. When we're talking about a basic estate plan, a will is just one document, one tool that we use. The other three really deal with incapacity issues because there is a time frame from today until that point, years and years down the road, Lord willing, when you pass away, that there can be a potential incapacity. And then you're dealing with who's going to help with this and who's going to help with that. So an estate plan must include, of course, where do your assets go after you pass away, but it also includes what's going to happen and who's going to help before you get there. All right. Um, a good way to look at an estate plan is who's going to help, when are they going to help, how are they going to help. Okay. It's also who's going to inherit, when are they going to inherit, and how are they going to inherit. Okay. So that is covered through inheritance discussions and incapacity issues. And that's what we're going to get into a bit. Now, not everybody comes in and gets the same estate plan. As I shared, there's different levels or layers. Probate avoidance may be the goal for one, taxation may be for the goal for another. Asset protection or long-term care issues. So when we talk about the idea of preparing an estate plan, there are certain factors that go into play to help us decide what is the best recommendation for this client. And as I was just mentioning, the idea of a goal. Is it simply just to make sure my kids get my property? Then it's a will. Makes sense. If it's, which it should also always include, who's going to help me financially, who's going to help me if I lose capacity, who's going to help me with healthcare decisions, how am I going to minimize taxes, how am I going to avoid probate? So all of these goals come into play so that we, as the counselors and the attorneys, can make recommendations as to what the plan can include. Now, we also have to consider people. Who's involved in your estate plan? For some, it's family, it's spouse, it's kids. For others, it's aunts and uncles, nieces, nephews, neighbors, best friends, partners. There's many different people and players that can come into the scenario when we're creating an estate plan. One of the most important and difficult issues is family dynamics. We can have a real plain vanilla scenario, husband and wife and 3 kids, and that's who helps, and that's where the assets go. Everybody's healthy, everybody's an adult, nobody has any issues. It happens sometimes, right? Like the Waltons, it happens sometimes, but there's not many families like the Waltons. All right, you're looking at strained relationships. You're looking at strained marriages, perhaps with children or the client themselves. You can have addiction issues. You can have incarceration issues. You can have special needs and disabilities. You can have unknown heirs as far as unknown whereabouts. Where are they living? We've had families where clients have children that are homeless and they haven't unfortunately seen them in a couple of years. Family dynamics definitely comes into play, and when we're creating an estate plan. Also, we have to consider the client's age. One of the more hot topics is, as of late, especially as kids are getting back to school after the pandemic and so forth, is if you have an adult going to college, 18, 19, 20 years of age, there should be a plan in place. There should be a power of attorney, which I'll talk about. There should be healthcare documents, which I'll talk about. And that's, again, young adults. But are you 90? Are you 92? Are you 93 years of age? There are different documents that come into play. Still the basic foundations of what we're talking about today, but perhaps we're layering in different types of trust vehicles to accomplish different goals or to help alleviate different family dynamics. So there's a lot that goes into based on the age of the client that we're working with. Health, of course, comes into play. Now, health can turn on a dime. We can prepare an estate plan for a healthy 50-year-old today, and something occurs tomorrow. So we always have to build flexibility into the plan so modifications and changes can be made. But looking at the client as we're making our recommendations and as we're implementing a plan, the health is very, very important. Are we dealing with an individual with a chronic illness? Are we dealing with an individual that has cognitive decline, activities of daily living concerns? Are we looking at long-term care issues? So of course, health issues will dictate what we're going to recommend as we build and recommend an estate plan. And of course, and you've been waiting for this, assets. That certainly plays a role. If we are preparing and working on a client with $10 million in assets, it is different than a client with $100,000 in assets. Same attention to detail, same concern, same respect, same loyalty to that client. And we're going to do the best we can, but there's just different strategies. So whether again, it's an age issue or a health issue or an asset issue, different recommendations based on different variables there. Okay, so hopefully that makes sense. Now, what exactly are the estate planning basics? So there's 4 documents. The basic 4, the core 4, different attorneys call them different things, but it's always going to be a last will and testament. And I'll get into this individually, each document right after this, but a last will and testament foundation cornerstone document. In addition, a power of attorney. Okay, I'll explain that a little more detail. A healthcare proxy and a living will. Those are the 4 basic documents that every individual should have, regardless of age and regardless of health. Okay, regardless of money, regardless of assets. These are the 4 documents. Now, to talk about it and to kind of peel the layers back a little bit, what is a will? What is a last will and testament? Well, it's a written document that is the simplest, cleanest way to effectuate a will, to make your will valid. Has there been cases in courts about oral wills and digital wills coming up with technology and so forth? Yes, but for 99.9% of us, it needs to be a written document that lays out your wishes. All right, so let me keep going with my points here. It's important to realize also that a last will and testament does not cover all of your assets at all. It deals with the assets that are in your name solely. It does not govern assets or control or distribute assets that are joint with somebody else. A will does not control or distribute your assets that have beneficiaries. And it does not control or distribute your assets that are owned by a trust. The will is here to govern, control, distribute assets that are in your name alone. Okay. Now, when a client passes away, we can have assets that are jointly owned. That joint account will pass automatically to the surviving joint owner by operation of law. We don't need a will to help us distribute that property, that account. We can have an asset like an IRA or an annuity or a life insurance policy with a contract beneficiary. Client passes on, owner passes on, the beneficiaries fill out a claim form. They are entitled to they receive what they're entitled to. You don't need a will to govern that asset, all right? The beneficiary forms control that. You can have a trust own certain assets, again, revocable or irrevocable. You want to know more about those differences? Go to our website, tullyelderlaw.com, click on videos and look at our prior webinars. I talk about revocable and irrevocable, the pros and the cons of both, okay? But regardless of what type of trust, if your house is owned by a trust or your investment account is owned by a trust, then that trust is going to control where that asset goes after you pass away. A trust is nothing more than a written document that really details how to manage a certain piece of property while the grantor creator is alive. Then perhaps while that grantor creator is ill or undergoing long-term care issues. And then ultimately, what should the trustee do with that property after the grantor creator passes on? So because all that is laid out in the trust and the trust actually owns the asset, there's no need for that asset to go through the last will and testament, okay? Hopefully that explained it. Now, interestingly, a will is not valid when it's signed, all right? Again, the will needs to be in writing. The testator or testatrix is the old-fashioned woman name for a female testator. Now, testator just covers everything, of course. So a testator signs at the end of the will. It's witnessed. 2 witnesses in New York. You have an affidavit at the end that the witnesses also sign that states the testator understood and could read and write the English language, had capacity, that it was supervised under this attorney, et cetera, et cetera. That is a typical will these days, all right? That's the will document. Now, that will isn't valid, believe it or not, until a judge says so. And that is the probate process. Again, clients have good questions, and I'll get this question quite frequently. Why do I have to go to court? Why do I have to go to probate if I have a will? The unfortunate but very real answer is that will is not a valid will until the surrogate judge in the surrogate court, Mineola, Riverhead, Jamaica, Queens, Manhattan, each county has its own surrogate judge in the surrogate's court. Once that judge determines the will is valid and admits it to probate, then the will is valid. Then the executor is officially appointed executor. Then the executor can marshal the assets left in the decedent's name. Then the executor can pay the creditors, ultimately distribute the assets to the beneficiaries. Okay, so probate is a validity proceeding, and it should be avoided. Why? Because it can be avoided. And I just shared with you how, right? You could have joint accounts, you can have beneficiary accounts, you can have trust-owned assets. Those three ways avoid probate. Probate should be avoided because the timing, it takes anywhere from 5 to 10 months for a probate proceeding to get moving and should wrap up. If there's any type of contest or challenges among the heirs or beneficiaries that think they should be included, you could go on for years, okay? So the idea of avoiding probate is to save time. It saves filing fees with the courthouse. It saves legal fees. And most importantly to me is it keeps things private. A probate proceeding is completely public. And there are literally entities and companies in the clerk's office. They are just really harvesting the data, as I put it. And you don't need that these days, all right? You want to keep things private. You want things to be efficient. You want to save money. You want to save time. And the way you do that is avoid probate. So a probate avoidance plan, which I'll talk about in a little bit, should certainly be incorporated into your estate plan. It's not necessary, but the will is necessary, okay? If you have any questions about that, again, just put your comment or question in the chat box or the Q&A, and I'll be happy to look at it at the end and hopefully answer it for you. So after the will, that main document, what we're looking at is a crucial document. I sometimes call this the most important document out there. It's what we call the power of attorney. Power of attorney is where you are appointing somebody to handle your legal and financial matters, okay? Now, we have a new form. New York State, by statute, creates the power of attorney form, and it's where a principal can appoint an agent to make decisions, all right, for the principal. It's delegation. It's all about delegation. And so the principal, for example, if I sign a power of attorney appointing my wife to handle my legal and financial affairs, she can do that. Where it really comes into play is the idea of it being durable, right? The idea that it will remain valid during any incapacitated. So the power of attorney that we have is one that's going to be good for while you're alive and well, but also as you age or deal with that incapacity that I was talking about earlier. The patient that the agent that you appoint is what's called a fiduciary. That means the agent must act in the principal's best interest. I'll give you an example. Again, if my wife is we'll do a different example. Let's say Mr. Smith appoints his neighbor to be his power of attorney, all right? There's no direct family. The neighbor is as close as he can get. He trusts him. So Mr. Smith appoints the neighbor to handle his financial affairs. Now, as a fiduciary, the neighbor must put Mr. Smith's interests before his own, okay? So I'll give you an example. If Mr. Smith has a car that he has to sell, that agent needs to sell that car to get the highest value, the highest fair market value for that car so that he could do the right thing by Mr. Smith, the principal. However, if the agent says, you know what, I want that car and I can just buy it for 10 bucks, that is a breach of the fiduciary duty because he's not doing what's in the principal's best interest, okay? I do say that this is the most important document because it's through this power of attorney where the agent, the right agent, can effectuate all types of asset protection, income protection, Medicaid issues. That's all through this document. It's very, very important document. As I shared, it's all of the legal and financial affairs. I've shared the durable component. It has to be durable. If you have a power of attorney that does not say durable on it, that does not have a sentence inside it that says this power of attorney shall remain valid even during my subsequent incapacity, then you do not have a durable power of attorney. It is good for that day. It is good while you have capacity, but the moment you lose capacity, without that durable language, it goes out the window, all right? Modifications. Probably one of the most important points when it comes to a discussion about powers of attorney, because I see it every week and it causes a problem every week. When we sit with a client, hopefully there's capacity, or if we're sitting with a child of a client or a spouse of a client, we're hoping there's capacity within the client so they can participate, make decisions, sign legal documents. If capacity starts to decline, it doesn't mean capacity is lost. It's just starting to decline. There can be short-term memory loss. There can even be a dementia diagnosis. That does not mean the person does not have the appropriate capacity to sign a power of attorney document. But if the person has capacity, they can handle their own affairs. If the person does not have capacity, you need to have a proper, comprehensive, modified power of attorney in place so that somebody can handle the legal and the financial affairs. Now, when I say proper and comprehensive, it's about the word you see on your screen there, modifications. New York State has had a power of attorney form. They've done it, they've changed it on us a number of years throughout the year, throughout my career. I've been practicing for 23 years, just estate planning work and elder law work. It was modified back in the 90s. The power of attorney was changed again 2009, changed again 2010, and then, yes, just changed again 4 weeks ago. All right, so we have a new form that was released by the New York State Legislature on June 13th. So of course, any clients we're meeting with these days are having the new form. But what's so crucial is just having a power of attorney is not enough in our world. When we're meeting with folks and planning for the future and planning for asset protection and planning for long-term care down the road, we need to take advantage of the modification section, okay? What that means is the power of attorney for the last 10 years and the current power of attorney has a section that says modifications optional. Now, in an ideal world, the estate planning attorney, the elder law attorney is filling that modification section with everything pertinent to, again, asset protection, income protection, Medicaid work, taxation, and so forth, so that the agent has the complete authority to be able to handle, again, Medicaid work, tax issues, whatever comes their way, they have the official authority to handle it. When we're sitting with a client with a power of attorney, that's great. But if it doesn't have the modifications, there might as well be no power of attorney. If we have a power of attorney that doesn't say protect my assets or allow my agent to protect my assets and protect my income, we're still going to have problems, okay? So the durability aspect, the modification aspect, crucial, all right? Using the right form, June 13th, 2021, very, very important for it to be valid. Now, what happens if there is no power of attorney? What happens if the power of attorney doesn't have those modifications and capacity is lost? We get forced into something that's not very nice or pleasant. It's what's called a guardianship proceeding. So as I was sharing, if a client comes in with capacity, great. If a client comes in without capacity, but we have a power of attorney that's durable and has modifications, that's fine. We still have an acting agent that can do whatever's necessary. But if there's no capacity, if there's no power of attorney or there's no modifications, which happens more than you think, then we may be forced into a guardianship proceeding. That's where a petitioner, somebody interested in the situation, has to engage a firm and petition the court to say, this person, alleged incapacitated person, is in jeopardy of harming themselves financially, or perhaps in jeopardy of harming themselves physically or health-wise. And therefore, the judge and court need to step in, literally strip that person of their decision-making authority, and perhaps appoint me as the guardian of the person for healthcare decisions and guardian of the property for all financial and legal decisions. It's not a fun process. It can be very stressful. It can be very costly. It's not something you want to go through if you don't have to. And the good news is you can avoid this entire guardianship proceeding by having, you guessed it, right? The power of attorney with all the modifications, okay? So get this done. It's why it's crucial to have it done as part of your basic planning. It's why parents of college-age students should have their college-age kids signing this, because God forbid something happens in college, the parent needs to be able to access different accounts or schedules or benefits, make healthcare decisions, and through this and through the healthcare proxy, they can do that, okay? So next basic document is what I just mentioned, the healthcare proxy. Very important document to have. Is it as important as the power of attorney to have? I'm going to say no, because there is a default law that covers this, whereas the power of attorney doesn't have a default law that covers it. But don't be lazy. Don't avoid the healthcare proxy. You still want it in writing. You want to appoint who you want to be your healthcare agent. So for example, a healthcare proxy is where you are choosing one person to help you with your healthcare decisions if you can't make the decision yourself. It only takes effect, it springs into effect if the capacity of the principal of the parent is lost, okay? We'll have children call us upset saying, Dad's in the hospital, and he's doing all right, but the nurse won't talk to me. I'm the healthcare agent. The nurse doesn't have to talk to you because Dad still has capacity, okay? So the healthcare proxy, one agent at a time, and it's triggered when that decision-making ability is in fact lost. The healthcare proxy document should include a HIPAA authorization. That's the Health Insurance Portability and Accountability Act. It's where you're giving your healthcare proxy agent the ability to access your personal health information. You've seen HIPAA, it's not new anymore. It's those 10 forms you sign when you go to the doctor. The healthcare proxy form, you can download it, you can get it from a hospital, but it's going to be missing, at least it usually is missing, a sentence, all right? There's going to be a couple lines, blank lines in the middle of every healthcare proxy form, and that's where a person who knows what's going on or talk to an attorney, or where the attorney actually adds the sentence in. It says that my agent knows my wishes about artificial hydration and nutrition. That's referring to feeding tubes. That sentence needs to be in there, and it's not in the standard form. It's not in the hospital form, and it's not in the form you download, okay? It needs to be in there, so there's that decision-making authority about feeding tubes. I referenced a moment ago that if the healthcare proxy doesn't exist, it perhaps is not the end of the world because of the Family Healthcare Decisions Act, this FHCDA. Again, Family Healthcare Decisions Act. New York, a number of years ago, signed into law a provision that states that if there is a hierarchy of people, a spouse or children, they can always make decisions for their relative, for their parent, for their other parent, for their siblings. But there's a hierarchy. And if there's 4 kids, who's it going to be? So even though we have the Family Healthcare Decisions Act that allows a family member to make decisions, you still want to put it in writing. You want the right child to be able to make those decisions and to be able to stand up and advocate for you if you're in a healthcare scenario. So yes, the Family Healthcare Decisions Act exists in the healthcare field. Again, nothing like that exists in the financial or legal realm with the power of attorney. If you don't have that power of attorney with the modifications, you're thrust into the world of guardianship. That doesn't necessarily exist here in the healthcare world, okay? Very, very important document. We like to keep it simple, all right? We just have the healthcare proxy do what the law says, which is to appoint a person to make decisions. Now, the living will is a separate healthcare-based document, okay? It is not a healthcare proxy. It is the statement, it is a general statement that the healthcare agent uses if we're dealing with end-of-life issues, okay? So the general statement is this: Should I be in an irreversible or incurable condition, I do not wish to have any medical treatments that merely prolong the dying process. In other words, as I tell clients every day, if I'm going, just let me go. That's what a living will statement says. If I've got one foot out the door, let me go. Do not keep me around artificially. If I'm passing, let me pass. Now, it then names specific treatments. I do not want ventilators. Very, very important topic, of course, after the last year that we've had. Ventilators, respirators, feeding tubes, dialysis, antibiotics. It states if I'm, again, at that point of no return, just let me go. It's important to realize that the living will does not necessarily involve, as I put it, 911 situations. If, God forbid, there's a car accident or stroke or heart attack, the living will should not be coming into play there. EMS will show up, stabilize, and get you over to the hospital. And that's perhaps where this discussion will occur. Again, the properly appointed healthcare agent will use the living will to say, I'm the healthcare person mom wanted. Mom did not want treatment A, B, or C. That's how that works. Now, the power of attorney will, the living will also say, I want maximum pain relief, okay? So while it specifically says, I don't want A, B, C, D, and E, do give me pain relief, all right? Important to realize that's in there. Now, I always like to share this with people because some attorneys, some very smart attorneys, differ as to how to do this and lay this out. We always have the living will as a separate document from the healthcare proxy. Again, the public health law creates the healthcare proxy document. It simply states appoint a person to make my healthcare decisions. The living will is not a statutory document. It was not created by the New York State Legislature. The living will was created by a court case that where a judge said in an end-of-life trial that if the patient had a quote-unquote living will that stated his or her wishes, then the court would know what to do. Then the healthcare agent or the physicians or the ethicists would know what to do in making decisions for the patient. So the way I explain it very practically to our clients is, if your spouse is going in for a procedure, absolutely take the healthcare proxy, give the healthcare proxy, leave the living will at home. It's not yet time to talk about those issues. I do not like the living will to be presented when it's not necessary, because to me, my gut feeling is it muddies the waters. I don't want people talking about end-of-life concerns and issues when we're just dealing with decision-making, okay? Some attorneys mix them together as one document. It says, I appoint John Smith as my healthcare agent, and by the way, I don't want ventilators, respirators, yada, yada, yada. I think, again, that clouds the issue. I don't want, as awesome as doctors and nurses are, I don't want them misinterpreting or making a mistake unnecessarily. So I like to keep it simple, okay? Very important document, and that kind of rounds out the 4 basic documents of a basic estate plan, all right? So that's estate planning 101. When we do those 4 documents for a family, it's what we call a probate estate plan. Again, it's going to be the will. It's going to be the durable modified power of attorney, the healthcare proxy, and the living will. Because we have a will that may be needed, I call it the probate estate plan. For some families, and we've been talking more and more to families about this, we like the probate avoidance estate plan more so, because what we're looking at is avoiding the courts, saving time, saving money, saving a lot of time and money, and saving privacy for the family. And the way we implement that is we take the basic plan, but we layer in a revocable living trust. And again, on the tullyelderlaw.com website, we talk about the different types of trusts. And I'm sure by the end of the year, I'll redo another topic, another webinar on revocable trusts. But it's a fantastic probate avoidance tool. We do a last will and testament. However, it's called a pour over will in this type of a plan. Of course, the durable modified power of attorney, the healthcare proxy, and the living will. If we're sitting with clients that are on the older side, generally 65 and older, we're going to be recommending what's called an elder care protection plan. And that also deals with a trust, but it's what we call our irrevocable asset protection trust. That's the one that will shelter the assets, if it's done right and done proper timing, from Medicaid and from nursing homes and all that down the road. And it also avoids probate. But again, that's just layered on to the basic estate plan. So of course there's a will, there's a durable modified power of attorney, there's a healthcare proxy, and there's going to be a living will. Now, a lot of clients that we meet with are those that actually have care needs already. And you'll see we're just really layering on the different work based on the factors and based on the specific circumstances of the client that I mentioned in the very beginning. So if we're dealing with an older client that has care issues, we're going to be recommending a life care plan. So first thing we do, make sure it's in place, is an estate plan. Those 4 documents, regardless of age or regardless of health. Asset and income protection also gets done for that client in that circumstance. Medicaid benefits, all right, to pay for care in the home or to pay for care in a nursing home if that level is necessary. And we do it very differently in that we have care coordinators on staff that will advocate to help your loved one get the best care possible. So regardless of circumstances, as I just showed you, you're going to have the basic estate plan. No matter where you turn, those 4 documents are going to be there. Okay. So any questions? That wraps up today's Wednesday webinar. We do have a question, so I'll jump into that. Please put your questions in the chat box. I'll be happy to answer them. Let me see what we got. Great practical question, Lisa. The question is, if you want to avoid probate, why bother doing a will? Makes sense. So if the plan is followed to a T, and if the client doesn't make a single mistake or oversight, I agree with you. You don't need a will. However, I don't want to take that chance. So if the revocable trust plan, probate avoidance plan, is going to be put into place to avoid probate, we'll have the revocable trust own a number of assets. We can have joint accounts that avoid probate as well. We can have beneficiary accounts, and of course, assets within the trust. Nothing solely owned. Therefore, the client passes, everything passes to the beneficiaries, no court involvement, home run. But there does come a time in some circumstances where an asset was not put in the trust by accident, or there can come a time where the investment company failed to actually make the transfer into the trust. Or you can inherit an asset years down the road and you forget to put it in the trust. There are things that can happen. So the pour over will, that's the complement to the revocable trust, is there just as a backstop. It's a safety net just in case, all right? So that's why it's important to have the will, all right? That's the only question we have in the Q&A box. I think we have, though, something in chat. Let's see. Oh, here we go. Can you please discuss the distinction between a living will and DNR and post? Great question. So as I've shared, the living will is a general statement of what I want as far as end-of-life conditions that end-of-life conditions that may occur to me in the future. A DNR is a medical form. The living will is the legal form. So DNR is the medical, where the doctor has or signs a do not resuscitate order. The DNR refers only to CPR, the cardiopulmonary resuscitation. Again, doctor has to sign that. They have community DNRs, they have facility hospital DNRs, different than a living will. Living will, again, is the legal statement. Now, post. So in New York, we have what's called MOLST, M-O-L-S-T. It stands for Medical Orders for Life-Sustaining Treatment. Other states have POST, which is Physician Orders for Life-Sustaining Treatment. I'll be honest, when this first came out a number of years ago, I was not a big fan. I've grown to appreciate and recommend the MOLST when it's necessary. But again, it's a medical form. It's not a form that a lawyer puts together. It is a bright pink fluorescent document. It is an active living medical order that the patient, your loved one, can take with you from hospital to assisted living, to rehab, to nursing home, to child's home. It is a living, breathing medical order that says, I do want this and I don't want that. Where a DNR, or discussion of hospice and all those issues, kind of happens 6 months or less of life expectancy. The most in New York is generally recommended by the medical community to be 12 months or less, just to start having the discussion. Excuse me. My general idea and thought on this is I would rather have, if I had to have a choice, because we're talking about a healthcare proxy, a living will, a DNR, a most. And by the way, I do have a separate webinar that I've done on this. And actually in August, I'm doing another one on just these healthcare directives. But the idea is to have a living, breathing person as your healthcare agent to make decisions, knowing your wishes, knowing you, knowing the facts at the time is the best way to go. Having the living will and the DNR and the most, very valuable and helpful. But to me, having that person that knows you and trusts you and you trust, knowing your wishes, make the decisions is the best way to go. Can you explain the difference between revocable and irrevocable? Okay, so, okay. So there's two different types of trusts. There's a revocable trust and there's an irrevocable trust. The revocable trust serves one purpose, and that is to avoid probate. Okay, great tool to have, younger, healthier, different goals, okay, goals of probate avoidance. Whereas the irrevocable trust is all about asset protection. And yes, it happens to avoid probate because that's one way to avoid probate is have assets in a trust. The irrevocable trust is used when there's a different goal. The irrevocable trust is used when we want to shelter assets and protect assets from something. It can be a creditor, it can be a lawsuit, it can be Medicaid, it can be a nursing home, it can be New York State. So irrevocable trust is 99% of the time used when we are preparing for long-term care down the road, okay? And that is, as I shared on the slide, the foundation of our elder care protection plan, okay? More questions. Okay, good question. If this is done, so the question is, if these are all done in the US, does it work outside of the US? And another part of that, even more finite, is if it's done in New York, does it work outside of New York? To answer that latter question first, we are New York attorneys, and a lot of this stuff is state specific. So if we base your plan on you being a New York resident and then you move to another state, it's always wise and prudent to have your documents looked at by an experienced attorney in that state. All the time, we're giving references and recommendations to attorneys in other states wherever the clients are moving, okay? So that's what you do. You get things checked out wherever you end up. Outside of the US, I think you're going to run into an issue as well. I think it's going to be even more complicated, and you should have an attorney, a counselor in that jurisdiction, that country, to look at the documents and what the wishes are, all right? And if that country has a corollary that does the same or serves the same purpose, then you should implement that, and you'd have two. You'd have your state-based, US-based, and your other country-based document, okay? Okay, how much control is lost? Good question. Once assets are transferred into a trust. So briefly, if it's a revocable trust, again, probate avoidance trust, not the asset protection flavor, then there is no control lost whatsoever. You are the grantor creator, you are the trustee manager, you are the full beneficiary. It is a revocable trust. It is your social security number. You can do whatever you want with the money, put it in, take it out, use it. That's revocable. In the irrevocable, again, a whole separate topic I've covered in other webinars. Please do check those out on the website, tullyelderlaw.com. But briefly, the irrevocable trust is actually pretty darn flexible and keeps control for the parent, for the client. For example, if we put a house into the trust, that client has the right to live in that house for the rest of their life. They cannot get kicked out. They can sell the house if they want with the trustee's involvement. They can purchase another property within the trust and still have it protected. They can, if there's a falling out with their trustee, which is usually a child, they can be fired. So you control who the trustee is. You can appoint another trustee. You can change beneficiaries. If you pick 3 kids and you want to add the grandkids or disinherit a child, you can still do that. So even though it's an irrevocable trust, there's a lot of control kept, okay? What else? You're welcome. All right. Thank you, everybody. Wait, looks like we have another question here. Okay, got that one. All right. Thank you, folks. A real pleasure. Please, every Wednesday, we're doing these. Get on our mailing list. through our website. If you're on this, hopefully you already did. If you register or watch one of our webinars on the website, then you will be registered to receive future notices of our webinars. Again, thank you. We're here to help. We do offer free consultations and look forward to seeing you soon. Bye-bye.